Hello, today's the 6th day of December 2017. My name is Jeff Barkler. In today's video, I will prove that the Federal Court Registrar, Colbran, admits the facts that she provided me with a false and misleading federal court document, and Judge Besanko omitted to rule according to the facts and laws, proving judicial bias in the federal court in the matter of SAD 403 of 2015, Barkler v. Colbran. Fact 1. On the 4th of November 2015, Federal Court Registrar Colbran issued a federal court false and misleading document when she stated, and I quote, "The court does not have jurisdiction to hear matters relating to the Criminal Code Act 1995, end quote. Fact 2. If you go on to the Federal Court of Australia website, under Acts which confer jurisdiction, right under the Crimes Act 1914 is the Criminal Code Act 1995, proving that Fact 1 is a false and misleading document from Federal Court Registrar Colbran. Fact 3. On the 13th of November 2015, I served a sealed federal court notice to admit on Registrar Colbran. Fact 1 of this notice, and I quote, "The fact is that the Criminal Code Act 1995 is a law of the Commonwealth," end quote. Quote, Fact 2. "The fact is that the Criminal Code Act 1995 does have jurisdiction in the Federal Law Courts of Australia," end quote. Please see other admitted facts. Fact 4. The Federal Court Rules 2011, Rule 2204, and I quote, "Facts or documents taken to be admitted if not disputed. If the second party does not serve a notice of dispute in accordance with Rule 2202, the second party will be taken to have admitted the truth of each fact or the authenticity of each document specified in the notice," end quote. Fact 5. The fact is that Registrar Colbran elected not to dispute the facts in the Federal Court sealed notice to admit dated the 13th of November 2015, and therefore she admitted the truth of each fact pursuant to Rule 2204 of the Federal Court Rules 2011. Fact 6. Registrar Colbran has admitted the fact that the Criminal Code Act 1995 does have jurisdiction in the Federal Law Courts of Australia, thereby admitting that she produced a false and misleading document violating sections 137.2 of the Criminal Code Act 1995 and section 142.2, abuse of public office, dishonestly causing a detriment to another person, that person being me. Fact 7. On the admitted facts by Registrar Colbran, Judge Besanko dismissed my claim. This is judicial bias and a gross miscarriage of justice. To the Australian Federal Police, the fact is that Registrar Colbran has admitted in a federal court sealed notice to admit document that she produced a false and misleading document and is in fact in violation of the Criminal Code Act 1995. Please investigate. To my Twitter friends, I filed and served a federal court sealed summons on Registrar Colbran for her to appear in court to face the charges against her, and she failed to appear to that summons. And when I requested that Judge Besanko require her to appear, he just said no. That demonstrated his extreme bias and prejudice, prompting me to ask him for his recusal. And given the fact that Judge Besanko ruled against the admitted facts and laws, proves beyond any doubt judicial bias against me and my case. Who in Australia can choose to ignore a federal court sealed summons? #judicial bias, #gross miscarriage of justice. Please share this video with family and friends, and thank you for watching.